Good morning and welcome to our webinar dealing with Brexit and intellectual property. I'm Georgie Collins, I head our London IP and media team, and I'm joined by Tina Lakhani, a senior associate in our regulatory and criminal team. We're going to be taking you through the key changes across certain IP rights, and Tina is specifically going to talk about post-Brexit packaging and labelling issues. We'll probably take around 40 minutes, so that there's plenty of time for questions at the end, and we've already received some pre-submitted questions. Thank you for those, and we will deal with those too. Just a flag, I've had a few technical issues this morning. BT is working on our area, so a little glitch with Wi-Fi. If I drop off, Tina will pick up, but fingers crossed, there's no glitches. So looking at the key changes. Next slide, please. Thanks. So all IP rights are impacted to a greater or lesser degree. The changes in position in relation to the protection and enforcement of IP rights after the 1st of January 2021 were dealt with by the withdrawal agreement, and this wasn't changed, at least not in any substantive form, by the UK-EU Trade and Cooperation Agreement deal on the 24th of December. There has been a labyrinth of statutory instruments to deal with changes to our UK legislation for IP rights. I haven't set these out in detail on the slides, it's rather dry and turgid, but if you'd like details, feel free to pop your details in a chat or ping me an email. So the main changes we're going to be concerned with today concern EU registered trademarks and EU registered designs, how this affects your brand protection strategies and what you should be thinking about, .eu domain names, geographical indications, parallel trade, issues around counterfeits and customs enforcement, and product labelling and packaging, which, as I say, Tina will cover. So turning to EU registered trademarks and designs. Next slide, please. This is really the biggest change for brand owners. If you had an EU trademark or an EU design registration as at the 31st of December 2020, a new comparable UK right will have been created and you'll have a new registration number. The newly created UK rights have been given a whole new numbering system so as to distinguish them from the existing convention for UK rights. So for example, a UK comparable trademark right will now start with UK 009 and then the last digits of your EU TM. It's a similar position for registered designs. The new comparable registration will retain the same filing, meaning priority date and renewal date, as the EU trademark or EU registered design. The UK IPO has created over 2 million new rights since the 1st of January. They have done an amazing job and have said the process of transfer has gone well. We have seen that in the main, but inevitably there are glitches, and we have seen some of those too for our clients. So if you haven't already, do carefully check your comparable UK rights have been created with the correct information, particularly the information around the filing date, priority date, and the renewal date, and that your representative, i.e. your attorney or your lawyer, or if you're representing yourselves, are all correct. It is possible to opt out of the comparable rights, and you should have a think about that relative to your existing and maybe future portfolios. If you've already got UK national registrations that mirrored your European registrations, you might not want to incur the additional cost and the administration of associating a new comparable right. You might not want to come into a conflict with a UK-based rights owner, particularly if you haven't used those UK rights, if you haven't used those EU rights, sorry, in the UK. If you do want to opt out, then there's a 9-month window from the 1st of January, so you need to do it by the 30th of September. The creation of these comparable rights now means that you'll have 2 renewal fees, one for your EU registration, one for your UK. And just as an aside to note, the comparable rights for an EU trademark don't extend to Gibraltar. It is possible to re-register the comparable right in Gibraltar, but you have to do that yourself. It isn't automatic. In relation to any applications that are pending at the 31st of December 2020, a new right wasn't created. Instead, rights owners can file a separate national UK application within a 9-month window from the 1st of January, taking you up to the 30th of September, which will enable you to claim priority from the pending EU application. As of the 1st of January, If you therefore require protection for a trademark or design in both the UK and EU, you'll need to make two separate applications. So make provision for this and in thinking how it informs your budgets. You've got double the cost of the application, the prosecution costs, the renewal costs. Next slide, please. Just turning to potential disputes in relation to EU registered trademarks and designs. In relation to any opposition or cancellation actions against an EU right at the EU IPO, after the 1st of January, it will no longer be possible to rely on earlier UK rights in such proceedings. In addition, the comparable UK right that has been created may face separate new opposition proceedings at the UK IPO, notwithstanding the fact that it's got through the EU IPO. UK courts can no longer decide matters concerning EU trademarks or EU registered designs as from the 1st of January. So the situation we had before, where effectively one could get pan-European relief in relation to an EU-wide trademark in the UK courts, will no longer apply. If you are operating both in the UK and Europe, you will need to think about the dispute resolution procedures that you have for enforcement as between the UK and separately EU. Disputes that are ongoing before the UK IPO will continue as they were, and there will effectively be no changes. Safe to say the difference compared to the EU IPO is that EU rights owners will be able to rely on their EU trademark registrations and applications as earlier rights for the purposes of UK opposition proceedings. Next slide, please. So just thinking about some strategies. So watching services is something to really think about, and considering if you need to extend any existing watching services that you've got to the UK or EU or vice versa. It's really particularly the case for UK rights holders that might have been less concerned about EU rights in the past. So for example, there could well be priority type scenarios where these equivalent UK applications, which derive from a pending EU application as at the 31st of December 2020, are opted in between the 1st of January and that priority window of up to September the 30th. Those applications, if they are opted in into the UK system, will take precedent over any new fresh UK applications filed during the same time period. So something to ensure is that if you are looking at any fresh new applications post 1 January, do take care with your clearance searches to ensure that they are sufficiently broad and they don't just cover the UK, but they certainly look up to the EU, taking account of that window up to the 30th of September, where EU pending applications could transition into a UK mark. Have a think about any existing EU marks which have only been used to date in the EU and whether use can be made of the comparable mark in the UK going forward. The newly created UK comparable mark won't be liable to a form of revocation on the grounds that the EU trademark wasn't put to use in the UK before the end of the transition period. It's a real coup effectively for having already got a European trademark. So even if the EU trademark in the EU wasn't used in the UK, it can't be challenged for a period of 5 years. Other thing to do is to, again, see if there's any gaps in your protection as between the EU and the UK, and have a think about any licenses which may be impacted by the creation of these new UK comparable rights, and if there's anything that you need to do about those, particularly in the context of relevant transactions. Next slide, please. Turning to .eu domains, so entities established in the UK and non-EU citizens residing in the UK, they will not be able to hold, register or renew .eu domain names from the 1st of January 2021. Any relevant domains will be suspended with effect from the 1st of January 2021 up until the 31st of March 2021, and those domains cannot be used in any form, whether it's for emails, websites. They can be reinstated if the registration data is updated to meet the various eligibility criteria. On the 1st of April 2021, UK registrants will be sent a notice that the domain name is no longer eligible and is being withdrawn. From the 1st of January 2022, any of those .eu domain names which have been withdrawn will become available for others to register, which could create problems from just a general brand protection perspective and relative to the issues that we regularly see with sort of domain name brand hijacking. URID, which is the domain name register that administers the .eu domain, has set out very detailed information for UK registrants. If this does apply to you, you should have received an email from URID on the 1st of January notifying you of the suspension of your .eu domain name if you don't satisfy the effective residence requirements. If you haven't got it, check your spam filter. If you can't satisfy the establishment criteria, then consider alternative domain name strategies if, for example, you don't already have an alternative domain name portfolio. Next slide, please. Turning to geographical indications. So this covers products, often food and drink, which are synonymous with locations for their quality. So for example, Scotch whisky or Cornish pasties. The UK is setting up its own, has set up its own geographical indication schemes for food, drink, agricultural products, spirits, wine and aromatized wine, with new UK GI logos for these products protected under the UK scheme. From the 1st of January, producers will need to apply to the UK scheme to protect a new product name in Great Britain, and then to the EU scheme to protect a new product name in the EU and Northern Ireland. Producers or retailers of food and agricultural GI products produced and for sale in Great Britain and registered before the 1st of January will have until the 1st of January 2024 to change any packaging and marketing materials to display those new UK logos. Great Britain GI products that are protected in the EU can continue to use the EU logo in the UK in addition to the UK logo after the transition period. The UK GIs registered with the EU GI schemes will continue to receive protection in the EU, but all new Great Britain products will need to obtain the UK GI protection first before securing an EU GI protection. There might be further developments in relation to GI protection as part of discussions relating to free trade, both with the EU and other countries such as the USA. So this isn't a completely settled position, but it is the position to date. Next slide, please. Turning to parallel trade, counterfeits and customs enforcement. So in the European Economic Area, which comprises the member states of the European Union plus Iceland, Liechtenstein and Norway, there's a principle known as exhaustion of rights. And IP rights are considered exhausted, which means the IP rights owner can't oppose the importation, distribution or dealing with those goods once those goods have been placed on the market by the IP owner or with the owner's consent anywhere in the EEA. After the 1st of January 2021, IP rights in relation to goods which are being imported into the UK from an EEA country continue to be considered as exhausted. That is for the time being. The government is about to embark upon a consultation considering options for what the exhaustion regime should really apply, given the opposition to the current situation, which many rights owners feel is unfair, given there is no reciprocity in relation to the EU position. So an IP right owner may oppose the importation by third parties of goods into the EU from the UK, but doesn't work for the UK. Looking at customs and requests for the detention of goods, historically EU national borders can be requested to detain goods suspected of infringing intellectual property rights following a pan-EU application for action referred to as an AFA, which is filed with the customs authorities in EU member states. However, as of the 1st of January 2021, a pan-EU AFA granted by customs authorities in the EU will no longer cover the UK. Similarly, and there is some parity here, a pan-EU AFA granted by HMRC in the UK will no longer cover the remaining EU 27 countries. So as a result, if you want to protect your IP rights at the border in both the UK and the EU and the UK, you'll need to have an AFA covering both. In December, the UK IPO published some guidance, which you'll find on its website, which has indicated that from the 1st of January, it will be necessary to make a separate request via HMRC if you want to obtain an AFA for the UK. So some procedural changes there, rather than just dealing with the customs authorities. I'm going to pass to Tina now, who's going to help navigate you through the issues relating to product packaging and labelling.
Thank you, Georgie. My name is Tina Nakani. I'm a senior associate in our regulatory team. So I'll be talking a little bit in brief about labelling and the major changes that you should be aware of. So as everyone knows, the EU and the UK have now agreed the terms of a detailed post-Brexit trade and cooperation agreement, and that did come into force from the 1st of January 2021. So in that agreement, as you may expect, there are a number of provisions that have been agreed relating to products conforming to technical regulations, mandatory marking of products, the labelling of products, cooperation on market surveillance, and non-food product safety or compliance. So I'm sure both UK manufacturers and EU manufacturers are probably most likely particularly keen to avoid costly redesigns or relabelling. And I will look through briefly at the major changes that the post-Brexit trade agreement brings in for you. Moving on to the next slide, please. So, looking at the key changes to the UK product regulatory regime from the 1st of January 2021, it's historically been the fact that in the EU that it's always been the CE mark that has been used, and that CE mark is still used in the EU, and that mark is used to illustrate compliance with EU directives that relate to that specific product. So, for example, it could be the low voltage directive, it could be a medical devices directive, and there's a raft of separate directives in relation to all sorts of different products that the EU directives deal with. And in the EU, the CE mark is still used. So, looking at the changes now post-Brexit, the EU directives were largely implemented into UK law. So UK regulatory requirements from the 1st of January 2021 will generally actually probably be the same as the EU regulatory requirements. So looking at the law and the legislation in relation to that, and if you wanted to particularly look up any product or amendment, there are a raft of amendments that have all been set out in a regulation, and that regulation is called the Product Safety and Metrology Regulations of 2019, and that came into force on the 1st of January 2021. So the Brexit related changes to the UK regulations are set out in that regulation, and there is a whole detailed list under that regulation if you were to look that up, and that details various things from toys and safety in relation to toys, the CE mark, and all sorts of different products if you wanted to look that up. I'm not going to go into detail into each of those amendments now, but if you wanted to ask a question at the end or drop me an email, I'd be happy to come back to you on that. Next slide, please. So looking at some of the major changes that we will be dealing with post-Brexit, one of the major changes is the fact that the UK CA mark has now been introduced, and that is the UK Conformity Assessed mark and UK Declaration of Conformity for products in Great Britain. So that mark will replace the CE mark in the UK, and the regime is the same as the previous CE marking regime, but with the safety and compliance standards, authorised representative responsible persons and notified body requirements all now being valid for the UK only. So you can only have a UK CA mark for products that you're putting out in the GB market. For products placed on the Great Britain market, you will therefore have to transition to a UK-only declaration of conformity with the relevant UK laws and the application of a UK CA mark. Interestingly, for cosmetic products, a UK-based responsible person must be appointed from the 1st of January 2021. Moving on to the next slide, please. So looking at timelines and when you may have to make some changes, according to official UK government guidance, most CE marked products may still lawfully be placed on the Great Britain market actually until the 1st of January 2022. So that does provide you some leeway if you are placing products on the Great Britain market and you still have that CE mark. Certain products placed on the Great Britain market, however, will already require the UK CA mark from the 1st of January 2021 if those products are placed on the Great Britain market and they are governed by legislation requiring the UK CA marking and the conformity assessment has been carried out by a UK-based notified body. You would then need to have the UK CA marking on your product. That rule will not apply to existing stock that already has a CE mark and those products have already been placed on the market prior to the 1st of January 2021. Moving on to the next slide, please. So looking at placing products on the EU market and notified bodies. So if you are a company that has exports and you sell in the EU market, obviously, it's important to note that the UK CA mark will not be recognised in the EU. So if you are following those rules and going about getting a new UK CA mark, you may want to obviously think about that carefully because in the EU, you will still require this CE marking. Some companies and business owners may therefore, if they are placing products in both the UK and the EU, you might want to think about having product safety requirements that comply with both the UK regulations and the EU ones. You may also want to think about perhaps having both markings on your product, so having the UK CA mark and also the CE marking if you have complied with both sets of regulations. That is allowed, and it's perfectly acceptable to have both markings on your products. So if you carry out conformity assessments, if conformity assessments are carried out by UK bodies, they will not be valid for EU compliance. You will have to have an EU conformity assessment carried out. Manufacturers whose products currently rely on third-party conformity assessments carried out by UK notified bodies will now require new conformity assessments to be carried out by EU-based notified bodies if you want your product sold in the EU market. So please do be aware of that. That is a big change, and you will need to make some arrangements in relation to that if you are placing if you are placing products on the EU market. Do think carefully about that and who the notified body is. And moving on to the next slide, please. In relation to food and drink labelling changes, thank you to Georgie who briefly covered the GI logo changes. There are quite a few changes in relation to food and drink labelling, and I won't be going through all of the changes here on this webinar today, but again, please do feel free to either ask any questions at the end or to drop me an email. My contact details will be on the webinar at the end, but I will briefly run through some of the main changes in relation to food and drink labelling changes. So food labels, just a summary. Food of animal origin, FOAO, placed on the EU market before the 1st of January 2021, those products can continue to circulate within the EU market without any labelling changes. If you have food of non-animal origin placed on either the UK or EU markets before the 1st of January 2021, they can continue to circulate both in the EU and UK markets. However, all food placed on the EU market from the 1st of January 2021 will have to meet EU rules. Moving on to the next slide, please. So maybe some of you are producers of food products and will be looking at your packaging in relation to the EU organic logo if you have organic products. You might be interested to know this. It's a recent update, as far as I'm aware, and that's in relation to the EU organic logo. And as part of the trade agreement, the EU has now agreed to recognise the UK as equivalent for organics until the 31st of December 2023. And that is actually on top of the already agreed recognition of UK organic control bodies and the UK recognition of the EU as equivalent. So this means that the ability for UK certified goods to be sold as such in the EU is guaranteed for longer than before. So there is some leeway there up until 2023, but it may be something on your mind and something that you do want to think about, and we will need to keep on top of changes in relation to how that might change in terms of the EU organic logo come 2023. But you can use the EU organic logo up until then. As I've said, the EU has now recognised the UK as equivalent for that purpose. And moving on to the next slide, please. As most of you are probably aware, the EU emblem, you must not use the EU emblem on goods products produced in Great Britain, England, Scotland and Wales from the 1st of January 2021 unless you have specifically been authorised by the EU to do so. So no more EU emblem on your products. And next slide, please. So looking at the enforcement of these regulatory changes and how the new changes will be enforced. Local authorities in Great Britain are responsible for enforcing labelling changes, and they do have certain powers under legislative rule. Trading standards, some of you may be aware, have powers to prosecute, as do local councils. They have also prosecuting powers and powers to enforce improvement notices. So you should always be aware of trading standards. It's often the case that companies report other companies to trading standards or the local council. The local council often do investigations, they do door-to-doors, they may come into your premises to have a look around, they may ask to check some of your packages or labellings to see where you are exporting to or if you're importing, and they may check what labels you have on there. Investigation powers do include interviewing you under caution if you're the director of the company. If that does happen to you, you should always request a solicitor to be present in an interview under caution. Anything that you do say in an interview under caution can be used as evidence, so it's really important that you do ask for someone to be present with you. You do have that right, and it's not always the case that you'll be forced to go. It might be that they contact you by letter or email. They may invite you to come in on a voluntary basis. They may suggest that you don't need anyone, and my advice is that you don't speak to the local council or trading standards until you seek legal advice. So I suggest you don't discuss the matter in relation to your products or labelling until you have sought legal advice, and that you tell the trading standards and local councils the same. So just beware of enforcement, and there are powers available to the regulators in relation to this, and enforcement is looked upon quite seriously. And moving on to the next slide, please. So that concludes my short piece on labelling. I know I haven't covered everything in detail there, and as I've said, if you would like more information, please do get in contact, especially on the food and drink side of things. There's lots of rules in relation to various different foods, such as eggs and wines and things, so do get in touch if you need any more information on that. As I said, that concludes my short piece. Thank you for listening, and I will hand back to Georgie. Thank you very much.
Thank you, Tina. So if anyone has any questions, please do post them in the chat and we can take them. We've got a couple of, we've got several questions that were submitted in advance. So one of them, I'll take a couple of them because they're directed to specific IP points. So one is about trademark watching. What is that and why do I need to be worried about it? I'm not sure you need to be worried about it. You definitely need to be thinking about it. So a trademark watch, well, watching services in general, there are tools that you can use, particularly where you've secured registered IP rights, that can effectively be your eyes and ears, that give you advance notice where third parties might be encroaching on your rights. And those which are particularly helpful to brand owners are trademark watches. They can be specific to a geography, so you could just have a watch on a trademark in the UK which looks at your trademark, your name or a logo, and what that will do is it will tell you if there are any third party applications for registration which might be identical or similar to your mark, which you might take objection to. That's really helpful because often we find that clients find out someone else might have registered a mark to which the client hasn't been alerted by a relevant trademark office and has been using it for some time, and then it's quite difficult to unravel that situation. So it gives you a quick heads up and can often, in the event of a conflict, enable a resolution at an earlier stage. And as I say, you can get sort of what I call those trademark watches on a national basis. You can get them on a worldwide basis. Similarly, you can get things such as a company name watch. Again, it's often one of the first signs of where there might be encroachment on a brand owner's rights, where somebody registers a company name that might be too similar. There's the misconception that Companies House will intervene and deal with that, but they generally will only intervene if it is pretty much identical, and small differences such as, you know, something in brackets in the company name will be sufficient to distinguish it from all other matter. So that can help. Domain name watches too. In the context of what we've been talking about today in terms of the changes as between the UK and the EU, I think, as I mentioned, if you've seen yourself predominantly as a UK rights owner, you really need to be thinking about Europe, certainly up until the 30th of September from a registered trademark and registered design perspective, and thinking about how pending applications in Europe could be consolidated into the UK. I think there's one further question which concerns the opting out of the comparable right and asking for some more examples why someone might want to do that when effectively they're getting a free national UK trademark registration. So maybe I'll illustrate that with a an issue we're dealing with at the moment, which is where two parties are in conflict. One is predominantly, well, one is UK based, it's where it has established its brand. Another party is European based and has never used the trademark which it has, which is the same as our client's trademark in the UK at all. The offending party has got an EU trademark, which has been cloned as a comparable UK right. However, it's got no rights to use in the UK. So in that instance, that would be a situation where that sort of European trademark owner, we would be saying, should be asking to opt out of the UK right, because otherwise its use in the UK of that mark will effectively infringe on our client's rights, particularly in relation to, say, something like passing off, where our client based in the UK has had a very, very long established reputation. So hopefully that gives a little bit more gloss on that. I can't see that we've got any further questions coming through. So on that basis, I think we will wrap up. If I can just mention, our next event is coming up on the 24th of February. It is an employment and immigration webinar. Details will be sent around in the follow-up from this session. There we go, posted on screen. So it'd be great to see you that. If you have any questions following on from this, either for Tina or myself, please do get in touch with us. Thanks very much for joining and take care of yourselves. Goodbye.